My name is Gian Micah De Jesus. I'm a junior associate attorney here at Solely Law Firm, and I help handle the commercial litigation, corporate and business transactions, and intellectual property cases. So today we're just going to be discussing the Federal Trade Commission, or the FTC's, new rule on banning non-compete clauses. Non-compete clauses are essentially provisions in employment contracts that limits an employee from working for a competitor or starting a competing business within a certain geographic area. So typically it'll say something like within this many miles in a time period, so within X amount of years after the employment ends. The motivation behind the FTC seeking to ban non-compete clauses kind of stems from this finding and these thoughts on non-compete clauses violate the fair trade laws and harm workers by reducing competition, lowering wages, and preventing the formation of new competing businesses. And the FTC found that there was this negative impact that it had on its workers. So it forced them to stay in unwanted jobs, forced them to endure significant hardships like relocating or having to go through litigation in order to fight these non-compete clauses. And so upon finding these, the FTC proposed their ban on non-compete clauses in January of 2023. So the final rule of the FTC, which was issued in April of 2024, declares that non-compete clauses are an unfair method of competition. And so the rule prohibits employers from entering into, enforcing, or representing that workers are subject to these non-compete clauses. So the impact that the FTC's new rule has on workers is that employers can no longer enforce these non-compete clauses on these workers, which the FTC defines as employees, independent contractors, volunteers, interns, and more. However, this new rule, there's an exception when it comes to senior executives who are in policy-making decisions and make at least over $151,000. This ban does not apply to them, and that was placed before the effective date of the new rule. So the impact that the FTC's new rule has on the employer side is that the employers are now required to give current and former employees or workers notice that they will no longer enforce the non-compete clause. So these are for already existing non-compete clauses that are deemed as an unfair method of competition per the definitions and the provisions found in the FTC's new rule. So employers are required to give these notices by the effective date of the new rule. And the FTC actually has a model language as to what the language as to what the notice should look like. But they also state that the notice must identify the person who entered into the non-compete clause with the worker, and it has to be on paper, whether that's hand delivering it, mailing the letter or the notice, or emailing it to that former worker. Now, there is an exception, however, if the employer does not have the street address, email address, or telephone number of this former worker, for example, then they are exempt from providing notice to that former worker as to the FTC's new rule. So there are some exceptions to the FTC's new rule, in which case the rule does not apply in these scenarios. So the first one would be the non-compete clauses related to the bona fide sale of a business, or clauses that accrued prior to the effective date. Another exception would be existing causes of action. So this rule does not apply to in scenarios where there's already a cause of action in place related to the non-compete clause that accrued prior to the effective date of the new rule. And finally, the last one would be a good faith belief, where the employer had a good faith belief that the final rule did not apply or it was inapplicable in this scenario. So the rule goes into effect 120 days after it is published in the Federal Register, which it was published in May of 2024. There is an estimated effective date of September 7 of 2024. If you have any further questions about this new rule or believe that this new rule applies to you as an employer specifically, please feel free to reach out to our firm, Solely Law Firm, as we represent employers here in Texas. Again, it is important for you to understand this as an employer, especially what this new rule means to your employment agreements with your workers or former workers. And if there's any updates that you need to make to agreements before entering into them, we would be more than happy to help you with whatever questions or work that you may need help with. Thank you so much for watching this video. Again, if you have any more questions, feel free to contact our firm. Please like and subscribe the video, and we hope to see you back here soon. Bye.